By the end of the 19th century, the United States faced a new economic problem, the rise of the trusts. Large business combinations could coordinate prices, divide markets, and concentrate control over entire industries. That is the context in which Congress enacted the Sherman Act in 1890. Section 1 targets agreements that restrain trade. Section 2 targets monopolization, attempts to monopolize, and conspiracies to monopolize. The statute was short, but its meaning had to be built by the courts. The first key case was United States versus Trans-Missouri Freight Association in 1897. Railroad companies argued that their agreement was lawful because the rates they set were reasonable. The Supreme Court rejected that argument. The early lesson was simple and strict. Competitors cannot replace rivalry with coordination just because they believe the result is sensible or efficient. Then came Addyston Pipe and Steel contra United States in 1899. This case is foundational because it gave antitrust some of its first real analytical structure. Pipe manufacturers had divided territory, arranged bids, and coordinated outcomes. In that setting, you can already see the outline of tools we still use today: a product focus, a geographic focus, and attention to how firms allocate business among themselves. Most importantly, the case helped crystallize the difference between ancillary restraints and naked restraints. A restraint may survive when it is subordinate to a legitimate transaction and limited to what is necessary. But when the restraint is the main point of the arrangement and its object is simply to suppress competition, it is unlawful. Next was Northern Securities contra United States in 1904. Here, the court confronted a holding company that brought competing railroads under common control. The court said Congress could prescribe the rule of free competition for interstate commerce. That mattered enormously. Antitrust would not look only at explicit cartels. It would also look at corporate structures that eliminated rivalry through ownership and control. Then we reach the most important case of the early era, Standard Oil Company of New Jersey versus United States in 1911. This is the case that made the rule of reason central to antitrust law. The court held that the Sherman Act must be construed in the light of reason, and that it condemns unreasonable or undue restraints of trade. That changed antitrust forever. From that point on, the question was no longer just whether a restraint existed, but what kind of restraint it was, how it operated, and whether it improperly suppressed competition. Finally, United States versus United States Steel Corporation in 1920 pushed Section 2 toward a conduct-based inquiry. The court said the law does not make mere size an offense, and it does not punish unexercised power by itself. It requires overt acts. That idea opened the path for modern monopolization analysis. Dominance alone is not enough. What matters is the use of that power through exclusionary conduct. So, these 5 cases gave modern antitrust its first architecture. Trans-Missouri taught that competitor coordination is suspect. Addyston Pipe gave us the distinction between ancillary and naked restraints and the early shape of market analysis. Northern Securities showed that combinations through corporate control could also destroy competition. Standard Oil established the rule of reason, and U.S. Steel made clear that monopoly law must focus on conduct, not size alone. That is how the Sherman Act became modern antitrust law in action and paved the way for all other jurisdictions.